Good morning and welcome to the BIA and the Specialty Contractor Council presentation on PAGA and why this is a threat to your business. I'm very excited to announce our speakers today. We have a great lineup for you, and I believe that you'll find the education and the discussion here worthwhile in understanding how PAGA is a threat to your business and what you can do to preemptively protect yourself and to be prepared if and when a claim does arise. Today, we have some exceptional speakers that are here with us. We will be hearing from Tom Manzo. Tom is the founder and president of CABIA, which is the California Business and Industrial Alliance. Tom has a background in business administration and also in strategic management and executive leadership. He runs a mid-sized manufacturing company with approximately 200 employees. And after being hit with a PAGA claim a few years ago, he realized how bad the laws were surrounding this topic and how it decimated businesses and really gave trial attorneys a way to legally extort money from businesses that are trying to do the right thing. With that, Tom went out looking for another organization that would help to fight PAGA and didn't find any. And therefore, he founded CABIA as the sole voice in California that's really standing up against this bad legislation and against laws that are empowering attorneys to really abuse companies. So Tom has practical experience in the fields of management, in running a company, but also on the legislative side and on how we can go about fighting this. He is also a certified California law HR specialist. So he has an understanding of HR and HR law. And just as we all should for running our businesses, if we don't understand the laws, we're not adequately prepared to protect ourselves. We'll also be hearing from Marie Burke-Kinney from Procopio. Procopio is a well-recognized law firm that she practices in employment law and has done so for over 25 years. She's been recognized at several levels for being one of the top women in California in attorney associations, from several other groups that have recognized her for her work in the area of employment law. She's a regular speaker and is regularly cited in employment law cases. So Marie will also be sharing with us how we can help to protect ourselves. She works as defense for employers that are hit with employment lawsuits and PAGA cases. And for those of you that don't understand PAGA as we get into this today, PAGA is our short term for the Private Attorney General Act, which is what gives attorneys the right to step into the shoes of the state and to sue you on behalf of the state, empowering the state to collect fees and penalties, and for attorneys to line their pockets with your hard-earned money. So with that said, I'm excited to turn our presentation over today to Tom. At the end of our presentation, we will be answering questions. I would ask that if you do have a question that you go ahead and put it into the Q&A section of Zoom. So you should find a button in your Zoom chat window that says Q&A. And if you put the questions there, I will be moderating. I will watch for those questions and I will help to get them answered if they're not answered throughout the presentation. We may pause in the middle of the presentation to answer some of the questions depending on the relevance. Otherwise, our presentation will last until approximately 1:30, and we'll reserve the last 10 to 15 minutes for question and answer. And if there's a lot of great discussion going on, we may extend it for those that want to stay on the chat. Otherwise, we'll attempt to end around 1:30 promptly. And with that, I'm happy to turn it over to Tom, the founder of CABIA, for his understanding of what PAGA is and why this is really a threat to every business, regardless of our size.
Thank you, Jamil. I appreciate the intro. So let's see here.
Trial lawyers in California are abusing a law called the Private Attorneys General Act, or PAGA, to get rich. And they're harming the state's small businesses, nonprofits, and even labor unions in the process. PAGA was signed into law in 2003 by then-Governor Gray Davis. He said it would empower workers. Instead, the law became a lucrative scam for trial attorneys. Here's how it works. Trial attorneys figure out that by threatening businesses with PAGA claims for labor code violations, they could quickly reach out-of-court settlements. sometimes for millions of dollars. Because the state labor code is more than 1,000 pages long, even the smallest misstep, like late lunches or a typo on a pay stub, can lead to a PAGA claim with crushing financial penalties. More than 35,000 PAGA notices have been sent to employers since 2004, but that doesn't mean employees are benefiting. In 2018, Uber settled a PAGA lawsuit for $7.8 million. The attorneys kept $2.6 million. The state took $3.6 million, and the drivers took home just $1.08 each. Other settlements are similar. One top PAGA attorney even admitted that the law was never intended to compensate employees. California needs to enforce its own labor laws and stop empowering trial attorneys to extort businesses and deceive employees. To learn more, visit cabia.org.
Hold on, I got one little technical difficulty here. Sorry.
Tom, that's the first time I saw that video. That's impressive.
Okay.
While Tom's getting his slideshow up and running, I wanted to just share with you guys, some of you guys may know me from around the association, maybe asking, hey, why is Jamil on this presentation and what do I have going into this? I was able to meet Tom and had an existing relationship with Marie's firm, Procopio, because our company was hit with a PAGA lawsuit, and it's something that we're in the middle of. And these are scary things because they don't have to be real crimes that you've committed. They just have to be accusations that an employee makes and that a trial attorney can just latch onto and twist and manipulate. And what they do with these is they take them and turn them into a trickle-down effect of one accusation leads to another accusation, leads to another, meaning if they say you didn't pay an employee their full wages, that can turn into, well, now you failed to pay the minimum wage. You failed to pay proper overtime. There's pay stub violations. And each of these accusations comes with their own penalties that these trial attorneys can go and seek. So I'm sure Tom will tell us more about that. And it looks like he's got his presentation ready to go.
Thank you. Thanks for stepping in, Jamil. Sorry about that, everybody. So we kind of know what PAGA is. We saw the video, and I think what people need to really understand is that they've grown more than tenfold since the law was created. And I think a lot of people really don't understand what it is until it's too late, unfortunately. California's Labor Law Digest, it's 1,100 pages plus, 300 plus laws, 9,000 rules, and one violation can lead to a PAGA claim. So yeah, one violation. So one labor law you might not know, California Labor Code Section 1198, Section C, a temperature of not less than 68 degrees shall be maintained in the toilet rooms, resting rooms, and change rooms during hours of use. And believe it or not, Big Lots is in the middle of a PAGA lawsuit over this. Their warehouse, they claimed that the restrooms were less than 68 degrees. And it's a class action lawsuit that's going to be a relatively large settlement, I'm imagining. Who's affected? I think a lot of times people think it's potentially just businesses, large businesses. I've got a call from somebody in the San Francisco area that has a decking company. He's been in business for 35 years. He has 4 employees, and one employee decided to file a PAGA claim against his company. Nonprofits, I talk to nonprofits all the time. Very small nonprofits are affected by this. Religious institutions, universities, hospitals, foundations. What it really adds up to is anybody that has an employee, it could be one employee, is at risk for a lawsuit if you're not complying with the labor laws. So here's some stats to consider. Our foundation recently released a study, and it's authored by the former California Department of Industrial Relations Director, Christine Baker, former Cal OSHA chief Len Welsh, and they found that the Private Attorney General Act pretty much has failed the employees, the employers, and the state. So the average cost of each case, think about this, is $1,231,000. And the trial lawyer's share is $405,000. So that's a lot of money. If the average cost is over $1 million, somebody that has 100 employees is potentially looking at this. In the Uber case, and we talked about the Uber case, and that was in our video. The attorneys got $2.3 million. Part of that $7.75 million settlement was $750,000 went to the company that distributed the checks for everybody. I mean, so not only the attorneys getting handsomely paid, so are people, the mediators, the people that are, dispersing the checks. That's why by the time it's all done and over with, the employees rarely get any money. Walmart case, $65 million because its cashiers were not provided with seats. The trial attorneys representing those employees, they got $21 million. They were able to get more money than they normally would get because they said they put so much work into it, and they persuaded the judge that what they did was really groundbreaking, and they were helping all of these cashiers by doing this lawsuit. And the affected employees, they got about $108 each. Google, $1 million settlement. State got $488,000. Attorney got $330,000. Each employee got $15 each. And it involved employees who were hired to review sensitive adult content. They were asked to sign a waiver of liability for exposure to that content, but apparently they said that they shouldn't have been exposed to that content, and that's how the lawsuit started. So I always tell everybody, we get a lot of calls. Our trade association, we have hundreds of members. We work with other trade associations. We get calls all the time. I just got sued. I just had this issue. I just had this problem. And I tell everybody, the paycheck stub is the most important component you can have in your company. I mean, this needs to be paid attention to more than anything else, because you have to think about it. If you have an employee who's disgruntled, fired, maybe they quit, they go and seek an attorney, the first thing the attorney says is, let me see your paycheck stub. So you have to make sure your paycheck stub is accurate, because if it's not accurate, it's definitely going to lead to one of these lawsuits. So you got to have things like gross wages earned, hours worked, number of piece rate units, if that's applicable, all deductions, net wages earned, the inclusive beginning and ending dates of the payroll period. Number 6 is something a lot of people get wrong. The name of the employee and the last 4 digits of his or her social security number or employee identification number. How important is employee identification number? There's a business in Sacramento that the time card said 1, 2, 3, 4, and the paycheck stub said 2, 3, 4, 5. And because they were not matched, it ended up costing the company $1 million. And a lot of people don't even believe that. How is that even possible? No harm, no foul. The problem was that paycheck stub was inaccurate. Name and address of the legal entity that is the employer. All applicable hourly rates in effect and the corresponding hours worked at each rate. So if you're dealing with, prevailing wage type jobs and things like that, you really need to make sure you're breaking down those different hourly rates on that stub. What are some of the frequent mistakes? Neglecting to list the total hours worked in a pay period. Really, really an important one. Leaving off the start or end date on the pay period. Listing the pay day instead of the end date of the pay period. Not having the employer's complete legal name. Listing something other than employer's legal name, like a DBA. Failing to include the employer's address on the pay stub. Not keeping a copy of the pay stub. So one thing that might end up happening is you could have an employee claim, hey, I only got this portion of the pay stub, or this is what that looked like. So we always advise employers to try to keep that documentation in the event they run into one of these type of cases. Listing overtime compensation, commissions, bonuses in a confusing way that's not going to fit the standard payroll template. And not having a place on the wage statement for items like double time, premiums that an employee was paid for, missed meal or rest period, shift premiums. So you really have to try to make sure you get as much of the data on that pay stub as you can, and it's as clear as you possibly can have it. So I always tell everybody, a lot of times the employees kind of get roped into these deals. And how do they get roped into these things? Because if you go on Facebook and you type in fired, laid off, any of those keywords, all of a sudden, all of these ads start popping in, and you can see they're saying, hey, reach out to us. You could be owed money. I mean, free holiday gift card to fired California employees. I mean, Lawyers for Employee and Consumer Rights are really an aggressive company. And you see them handing out things at places like Sam's Club and Costco, they're hang around churches. I mean, you would be amazed at how actively they're trying to pursue your employees. And the reason they're doing that is because they know there's a great deal of money that can be made doing this. Meet Mr. PAGA, Daniel Gaines of Gaines and Gaines. He's one of the top PAGA trial lawyers, and he drives around in his Rolls Royce. I mean, imagine you're in mediation and you're having to borrow money to settle one of these lawsuits, and this attorney shows up in his Rolls Royce boasting he's Mr. PAGA. So you just received a PAGA letter, and what's on this PAGA letter? 13 allegations. What normally happens is they'll accuse you of as many things as they can, and it's almost a fishing expedition because they want to see, okay, I know the paycheck stubs got an error. Let's find out what else is wrong. Let's accuse them of as much as we can, and what are those accusations? Violation of the Private Attorney General Act, failure to pay overtime, unpaid balance of overtime compensation, failure to pay minimum wage, uninterrupted meal periods, rest periods, reimburse expenses, wage statements. Did they keep accurate payroll records? I mean, they are going to name as many things as they possibly can. Unlawful failure to pay wages due upon termination. You might say, wait a minute, I gave that person their final paycheck. What do they mean by that? Well, if the paycheck stub was wrong, then they didn't get the correct wages that were due to them when they were terminated. And this creates more problems like waiting time penalties, which could be up to 30 days, 30 actual days of pay that you would owe this employee. Fines, penalties, PAGA imposes monetary fines on employers for each violation of almost every single provision in the California Labor Code. If the Labor Code does not already provide for a penalty, PAGA imposes on the employer a $100 fine for its first violation and $200 for each subsequent violation of the same provision. So these fines can be assessed for each employee for each pay period when applicable. So what they're saying is you're going to get penalized for every single violation, for every single employee, for every single paycheck stub. So if you pay somebody once a week, $200 for one penalty times, 52 is how much? And that's just for one employee. It shows you how quickly these lawsuits can truly add up. So lessons from the front lines of PAGA. So
I think this is B, Tom.
This is where you take over.
Yeah, Tom,
Okay.
You're
Sorry.
kind of depressing me. I mean, I live this every day as an attorney, and I'm hearing you, and I kind of feel a bit depressed here. I got to tell you, when PAGA was enacted in 2004, and we called it the Sue Your Boss Law, I remember thinking this was a pretty big deal. And I kind of couldn't imagine that, in 2021, 17 years later, this would just be dominating the employment litigation landscape in California. So back then, I got to admit, I was a little bit more kind of jovial about it. And I even made up a little tune. And if you indulge me for just a moment, I'm going to use my bad singing voice. And I used to sing, I could hire me a lawyer and then sue my employer if I only had a claim. I could round up all my buddies and we'd all make lots of money if I only had a claim. And I kind of thought this law was ridiculous. There's no way that this was going to stay on the books. And here we are 17 years later. And Tom, thank you for fighting the good fight to try to change the law. But the reality is it's here. There's no sign of it going away. And it's kind of a reality that every business has to face. So let's talk about how much of a problem it is on the next slide. When you look at the dollar value of these wage and hour claims in California, these PAGA actions, the top 10 employment litigation settlements in 2020 ranged from $2 million to $17.3 million. And 9 of the top 10 cases were wage and hour. In total, those 9 cases totaled almost $60 million, $58 million. These lawsuits are just cash cows for plaintiffs' attorneys because the attorney's fees are so easy to achieve compared to other litigation. So anecdotally, I remember one of the major cell phone wireless companies was hit with a PAGA claim, and it was a pay stub, and they just had something wrong in the employer's title name on the wage statement. That case settled in 30 days for $3 million, and the attorney's take-home pay for 30 days of work was $1 million. And so when you understand the economics behind this litigation, it's very easy to understand why these claims have skyrocketed in California. And as Dom's illustrated, even when the mistakes are minor, the employer may still be liable for penalties. So let's talk about the anatomy of how these cases get started. So an employee gets fired, they feel it's unfair, and they go and they talk to a labor and employment attorney. And they say, hey, I was laid off, but you know what? There was plenty of work. I shouldn't have been laid off, or I was fired, or I was demoted, or they put me on a performance improvement plan right after I claimed workers' comp. And the attorneys are like, yeah, you're a white guy under the age of 40. Let me see your pay stub. Let me see your time records. Let's do a labor code request for your personnel file, your wage records, and your time records. Oh, look at this. You've tons of late meal periods. You got them at 5 hours and 20 minutes instead of 5 hours and 0 minutes. And you have a ton of short meal periods. Instead of 30-minute meal periods, you got 29-minute meal periods. And the employees there saying, yeah, but I was wrongfully terminated. I want to sue for that. Yeah, you're not going to get anywhere with that. You want to hurt this company. This is how you hurt the company. You can go after penalties and you'll get a reward as the plaintiff. But what the attorney doesn't tell them is that their reward at the end of the day as the lead plaintiff is maybe about $5,000. But the attorney gets a third of the total recovery. So the attorney encourages the employee to become a plaintiff in a class action or in a PAGA action. And I've literally had mediators in the middle of a mediation have to spend an hour of time with the plaintiff explaining that they're not there to talk about why they were wrongfully terminated. They're there to talk about meal periods and overtime. And the employee doesn't actually understand because the lawyers are driving the bus on the PAGA actions. And these wage and hour violations, they're pretty easy to prove. I mean, there's 9 categories on the wage statement requirement. You miss one, boom, it's an easy claim to prove. And the attorney, as I said, recovers 1/3. So in the case I gave you the example, a $3 million recovery after 30 days, that's $1 million to that attorney. So these claims, like Tom described, there's trolling online, there's advertisements, but also a lot of the employment attorneys who bring these PAGA claims have reciprocal relationships with workers' comp attorneys. How does that work? Employee says, I got injured on the job. Okay. And then the workers' comp attorney sends the file over to a PAGA attorney, and the PAGA attorney looks through and says, oh, there's something wrong with the wage statement. And look, there's some late time meal periods. And all before you know it, the employee who just got injured on the job and just wanted to be compensated for time off work and get medical help is now a plaintiff in a PAGA action, because they're incentivized, they're told they're going to be a hero to the rest of the employees. But what they're not told is this is all about attorney space. So let's go to the next slide. Tom's covered quite a bit of this, but let's talk about the typical PAGA wage and hour claims. Meal and rest period violations. Meal period requirements in California is an employee has to get a 30-minute uninterrupted meal period within 5 hours of starting work. That's 5 hours and 0 minutes, not 5 hours and 1 minute or 2 minutes. Starbucks got sued in San Diego and a PAGA action went all the way to trial because Kylie Carrington, the plaintiff, had 2 late meal periods, 1 minute and 2 minutes late. And that case went all the way to trial and went up on appeal. And so, we're really talking about gotcha type claims where the meal period, instead of being 30 minutes, is 29 minutes, or maybe it's 5 hours and 1 minute instead of exactly on the nose, or maybe it's a missed meal period. So, and with rest periods, it's a rest period has to be provided every 4 hours or major fraction thereof, which is legalese for every 3.5 hours. So that's a very, very common claim. And thanks to the California Supreme Court, effective July 15th, when you pay the 1 hour of pay for an employee who misses a meal period or doesn't have a full meal period, you now have to do a calculation to include bonuses or incentive pay or commissions in calculating that hour of pay. So it's pretty straightforward. If you have an employee who earns $20 an hour and doesn't get any non-discretionary bonuses, it's $20 an hour if they miss a meal period. But if you have an employee who gets $20 an hour and they get a quarterly bonus and they get a monthly commission, you now have to go back and you have to attribute some portion of that commission or bonus to the week when they missed the meal period. That is is an unbelievable administrative burden that's been placed on employers by the California Supreme Court in calculating meal period premium payments. Off the clock work. Off the clock work sounds very, onerous or very kind of, dastardly for an employer to require employees to work off the clock work. But it happens kind of easily. It can be an employee's on the way out the door after having clocked out and a customer stops them and asks them a question. That's off the clock work. Or it's this preliminary and post-preliminary work. They come to work and they're putting on their safety gear and they haven't clocked in yet. That's off the clock work because it's not on the clock. Or Apple learned the hard way that when they do bag checks to make sure that their product's not leaving their store with their employees, they got hit with a claim for that time spent going through the bag checks. One of the worst claims I've seen in the COVID era, which is just almost despicable to me, is many of my healthcare clients being sued because nurses, LVNs, CNAs underwent a 30-second, 1 minute temperature check. And now they're suing for the 30 seconds or 1 minute that they were off the clock for a COVID screening. That's a screening that was mandated by the government, not the employer wanted to do, but many county health orders, as we all know, required temperature checks. California Department of Public Health required all sorts of screenings in skilled nursing facilities and hospitals, but employers are being sued regularly right now for these COVID screening off the clock claims. A quick training, a huddle in the morning. It can be a 2-minute huddle and employees are suing for that if it wasn't happening on the clock. So there's very little grace for employers with respect to these gotcha claims or mistakes. Untimely pay periods. If you pay semi-monthly, which is the 1st and 15th or 15th and 30th, chances are there's about 3 or 4 pay periods a year where you are not complying with Labor Code Section 204 on the timing for payroll. I have a client facing that right now in a PAGA action. Unpaid overtime. Either it's not recorded as overtime, so it was off the clock, or you didn't include bonuses and commission in calculating the overtime rate. Unpaid bonuses or commissions, unreimbursed business expenses, another popular claim right now. Employees who went home to work remotely due to COVID. Cell phone reimbursement, internet reimbursement, those claims are on the rise. Employees who use their personal vehicle for work, mileage, PPE, see claims like that both in construction, healthcare industry right now. Tools, failure to provide employees with tools. I have an asterisk there because if you pay employees twice the minimum wage, you can require them to provide their own hand tools. But these are all the types of claims that we're seeing. Misclassification of independent contractors. Well, of course, it's almost impossible now in California to have an independent contractor because of the ABC test. A, they have to be free from the direction or control of the business. B, they have to do work outside of the normal course of the hiring entity's business. And C, they have to be engaged in an independent trade or business involving the same work. Now, most of these independent contractors can satisfy the A and C part, but it's the B part, which is they have to do work that's outside the normal course of the hiring entity's business. So what's an example of that? Say you have an electrician. An electrician who works for a construction company can never be an independent contractor in the state of California because of the B part of the test. It's no mistake, it's the B part of the test, by the way. But an electrician who goes and performs a job at a retail store or a restaurant, they can be an independent contractor as long as the A and C parts are met because they're not doing work related to that business. A restaurant isn't in the business of electrical work. They're in the business of serving food. So that's another kind of hurdle and another obstacle for California employers. And then there's misclassification of exempt employees. A foreman's classified as exempt, but they only supervise one employee and they should be supervising 2 or more full-time employees, exercising discretion and independent judgment. Unpaid vacation or PTO or paid sick leave, a bunch of new COVID sick leave requirements came in the last 2 years, and we're seeing a lot of cases involving that. Tom did a great job addressing the wage statement requirements. And then if you owe an employee so much as $1 when they leave their employment, you're liable for waiting time penalties. What are those, you say? It's 30 times an employee's daily wage rate. How do you calculate that? Well, if an employee earns $20 an hour and they work an average of 8 hours a day, and you multiply that by 30, that's $4,800 in waiting time penalties if you didn't pay them so much as $1 of wages. And there's no kind of good faith exception there. The word willful is in the statute, but the courts have interpreted willful to mean you done it, you did it, you got it wrong. So again, very onerous, very gotcha type claims, and this is what we're seeing all over the map. But don't just take my word for it. If you go to the next slide, you're going to see.
I wanted to just touch base.
Oh yeah, jump in, Tom.
Really quickly on the cell phone, just because I think a lot of people really, especially in the industry that we're talking to today, don't understand how these gotcha cell phone situations can happen. You could text your employee at 7 o'clock at night and say, hey, I need you to meet me at this job site. You could have an employee that's at a job site and say, the wood came in and it's warped and it's bad. Okay, well, text me, send me a picture. Let me see what it looks like. Okay, I'm going to text you to the location to the next job site you go. You have to be really, really careful when you have employees who are hourly that are using cell phones for that type of purpose, and you're not reimbursing them. It doesn't have to be a huge reimbursement, but you should have like a cell phone policy, and it can be $5, $10 a month. It could be some form of reimbursement, but you really should do a checkup and find out how many people are using cell phones and they're not getting reimbursed for it. And I just think it's one area employers, especially in your industry, should be looking at. But anyway, go ahead, Marie.
I agree. That's a great point. I want to add to it. So where does that requirement come from? The labor code section is 2802. And what it requires is you must reimburse employees for expenses that are reasonable and necessary to the performance of the duties of their position. So why would an employee be required to use a cell phone? Well, a lot of employers take the position that their hour employees shouldn't be using their cell phone. But as Tom just illustrated, it can be a text with a photo at 7 o'clock at night and boom, they use their cell phone for a work purpose. And the employer is presumed to have known about that. The Radio Shack case that came out some years ago, it was a store manager fired for misconduct, brought a class action and said, hey, I drove my vehicle to get inventory or deliver inventory to other stores. And Radio Shack said, well, hang on a second. We had an expense reimbursement policy. We told you to submit. You never submitted the mileage expense. How would we even know that you were owed anything? And they thought for sure they were going to win on that. But the Court of Appeal said, no, hang on a second, Radio Shack. you had constructive knowledge that this store manager was using his vehicle for work purposes. How did you have constructive knowledge? The inventory reports. You know that they didn't magically apparate the inventory from one store to another. A human being had to get into a vehicle and drive it. So that is the standard that faces employers. Employees can be using their cell phone and you can be deemed to have constructive knowledge of it. So as Tom said, you want to do an assessment and look at whether employees are using cell phone, not just for a text at night, but what if they're using it for time entry? What if they're using it to take pictures of an incident on the job, a workers' comp injury? So it's important to have
email at night.
Email at night. It's important to have cell phone policy, a stipend that's reasonable and guaranteed to reimburse them for the percentage of their cell phone bill, because we learned in another case the Cochrane case, that it doesn't matter if the employee has one of those data plans where you have unlimited texting, unlimited calling. If the employee uses that cell phone for work purposes, they're entitled to a reasonable percentage reimbursement of their monthly cell phone cost. So that is why identifying if an employee you anticipate they're going to use their cell phone 2 times a week, maybe you give them $3 a month, but you have to let them come back and tell you whether that stipend that you establish is reasonable or not. And you have to have a methodology for establishing that stipend. Did you go online and see the average cost of cell phone plans in the United States, in California in 2021? And did you think how much of the cell phone use is personal versus business? If you don't have that, that's a very hard case to defend. So on the next slide, like I said, these are actually real court filings that I just excerpted. And I know it's a busy slide, but it was just to give you a flavor. And these cases were filed just in the month of September. So no, as Tom said, no industry is immune. It's not male or female, it's both. There's nonprofits, small, medium, large companies. And if you start up in the left-hand corner, it's a San Diego Center for Children being sued for overtime, minimum wage, meal periods, rest periods, business expenses, pay stubs, and waiting time penalties. Next down from there is swing education. You had a teacher who was misclassified as an independent contractor, claiming compensation for itemized wage statements, reimbursement, and wages. And then you have a lab being sued for overtime, minimum wage, meal rest periods, expenses, and pay stubs. Top right-hand side, you've got Lawyers for Justice, Mr. Edwin Edwazian, like Mr. Gaines, he's Mr. PAGA, and he sued a hospice company on behalf of a healthcare worker, claiming overtime, meal periods, rest periods, expenses, wage statements, waiting time penalties. You see the theme here? It's all the same thing over and over again. And then you have an electrical installer seeking penalties from an electrical contractor company for meal periods, rest periods, wage statements. You could just keep repeating after me the same claims over and over again. And the last one on here is a OS4 labor company. And the only unusual thing in there is they're claiming suitable seating. Now, Wage Order 16, which governs the construction industry, does have a seating requirement. It's a little less onerous than the other wage orders, but it basically says that you have to provide suitable seats to construction workers when the nature and process of the work performed reasonably permits the use of seats. So it's a real thing. And these are all very, very real claims. So if you go to the next slide, let's take a look at the different types of penalties that are associated with this. As Tom explained, the default is $100 for the first violation and $200 for the second violation, unless the labor code already has a penalty. So for overtime, which was mentioned in virtually all the court filings, it's $100 for the first violation, $200 for the next. For a meal period, that statute, section 512 of the labor code, happens to have a $50 penalty in there. So it's $50 for the first and $100 for the next. Rest periods, $50 for the first, $100 for the next, off the clock, $100 and $200, and the inaccurate wage statement, $100 and $200. Now, if you add in expenses and minimum wage, that's another $100, $100, $100. And all of these penalties stack together. So let's take a look at the 5 listed penalties and go to a real calculation on this slide for a company with 300 employees. Cumulatively, the penalties would be $400 per employee for the first pay period violation and $800 per employee per pay period for the subsequent violations. So with 300 employees, that's $6.12 million. Now, we've been successful in court, in multiple cases, striking the second penalty under a theory that the first penalty is only available if a court has never concluded that that employer, or the labor commissioner's office has never concluded that that employer committed a labor code violation. So if you are successful in striking the subsequent penalties, it drops down to 3.1 million. So if you have 100 employees and you're hit with both penalties, it's about 2 million. And if it gets cut in half, it's 1 million. These are very, very serious numbers when you're talking about a company that's trying to stay in business and make payroll. And there's rarely, if any, EPLI insurance coverage for these penalties. At best, what I see out there for EPLI insurance, employment practices liability insurance, is you typically have a deductible or an SIR in the range of $25,000 to $75,000. And once that deductible is met, there's maybe another $100,000 in defense costs, attorney's fees. But the company, the insurance company, will not insure you for the penalties. So you're on your own for that. And then the cost of defending these cases, candidly, it's expensive. When a case gets going and you're in full-blown discovery and you're having people sit for depositions and you're producing the wage and time records for hundreds of employees, you can be up to $40,000, $50,000 a month in attorney's fees burning through a defense of this case. So we know that litigation really only benefits the attorneys, and that's coming from an attorney. So what can you do to kind of position your company to be in the best position to defend against this type of case or prevent this type of case? My first piece of advice is do a thorough wage and hour audit. Make sure that you're looking at wage statements, like Tom said. Look at cell phone reimbursements, PPE, mileage, internet, all of those things. Make sure that you have a good timekeeping system. So pay for the actual times worked. A lot of payroll companies out there say, hey, you should round employee times, it'll save you money. Guess what? That's a problem in California because it's way too easy to bring a rounding claim. And one of the first things that an aggressive plaintiff's attorney will do will take the deposition of your payroll company and look at their marketing literature where they said, we'll save you money by showing you how to round your employees' times. And if that rounding overall benefits the company more than it benefits the employee, the court can and will hold you liable. So in 2021, you should be paying to the decimal point and don't be rounding, and certainly don't round meal periods. Adopt a robust meal and rest period compliance program. Have a policy and have a way of monitoring and flagging in your payroll system, your timekeeping system. Are there any late, short, missed meal periods? And go to the employees who had a late, short, and missed meal period. And if it was because of work, pay them an hour of pay. If it wasn't because of work and it was their choice because they weren't hungry or they wanted to go work out at the gym at 2 o'clock and not take their meal period at noon, document it because the burden is on the employer to prove that it was voluntary choice. And give yourself a cushion. Encourage early meal periods. Why not start them at the 4th hour? Why wait until the 5th hour? Anything can happen. The phone can ring, something can go wrong on the job site. And before you know it, you're late on getting your employees a meal period. Give them a longer meal period than 30 minutes. Give them a cushion. Maybe make it a 45-minute meal period or even 35 minutes, but give some sort of a cushion. Publish and enforce a strict policy of no working off the clock. Now, if you have clocks around a job site, I recommend a big poster that says no working off the clock, take your meal and rest periods. If you have them using a mobile phone app, have a click up, a little pop-up box come in where the employee can click. I acknowledge I'm not allowed to work off the clock and I have to record all my time and I have to take my meal and rest periods. And if they're logging into a tablet or a computer, a pop-up box like that is also a very good idea. That's good evidence to show when these employees bring these types of claims that the employer should not be hit with the full amount of the penalty, because the court has the discretion under the PAGA statute to reduce penalties if they would it would be unfair, confiscatory, arbitrary, or oppressive to require the employer to pay all of the penalties. What's the best evidence that it would be unfair to require an employer to pay the full penalty? The best evidence is that the employer had a good wage and hour compliance program. So some more tips for limiting the liability: make time reporting easy, have multiple clocks. I've defended cases in the manufacturing industry where employees will testify, there were 50 of us lined up to clock in, and by the time I got clocked in, I'd be already on the job for 10 minutes. That's off the clock work. Same at the end of the day. So if you are going to use a mobile timekeeping app, that is a red kind of a trap for the unwary, because now you have an employee using a personal cell phone device for a work function, recording their time. So that's where you'd have to have a stipend for the cell phone. Make sure you're paying for post-preliminary and preliminary activities. Make sure that they are clocked in before they start donning safety gear or doing a temperature check or anything like that. Include incentive pay, bonuses, commissions in the regular rate of pay for overtime, meal and rest period premium pay, and give employees an opportunity to correct their time records if they make mistakes. Confirm exempt employees are properly classified as exempt. All right, so
Hey, can I give one more tip? Can I give one more tip?
Yes, I love it.
So I like to tell everybody, if you're paying your employees weekly, see if you can switch over to you're paying them every 2 weeks, because you would reduce your potential liability in half. I mean, it's, and I know a lot of people say, well, it's hard to do it. Some situations you can if you're dealing with prevailing wages, but if you're in a scenario where you could pay everybody every 2 weeks, I would try to move to that pay period plan.
That's a great tip. Absolutely. All right, so you got a PAGA letter. What do? First and foremost, take it serious. Take it serious as a heart attack. I mean, really, you have an attorney knocking at your door, and they're there for one purpose and one purpose only. They want to sue your company because they want to get a third of attorney's fees. So I do recommend you consult with employment counselor or a very competent HR consultant, but consult with employment counsel immediately, because there's some things you can do to prepare the company for this lawsuit that's coming. I can't remember a single time other than once in the past 15 years where a client got a PAGA notice and a lawsuit wasn't filed. So that's kind of bad odds. Conduct the wage and hour audit, because you want to immediately check if there are any curable violations. The only real curable violation is a wage statement issue, and you have to go in and correct it and issue retroactive wage statements to your employees. You have 33 days to do that. I have gotten clients to do that, and they cured it, and they were able to do it before the lawsuit was filed. And you have to submit a letter to the LWDA saying, hey, we heard there was a problem with our wage statement. We went back, we fixed it. We mailed out all of the cured wage statements to our employees, current and former. And that's a real opportunity to cut off those penalties. Now, there's also going to be non-curable items such as meal and rest periods, or a client of mine just found out that when they were paying semi-monthly, they were off on the pay periods. So they just corrected it. January 1, they went to bi-weekly. And just know the lawsuit's coming in 65 days. Sometimes they jump the gun, they file it sooner. And if you see a PAGA notice, chances are there's a class action right behind it. So if you don't have arbitration agreements, and I double asterisk that because I want to talk about arbitration agreements in a moment, this is the time to think about arbitration agreements. You can consider release agreements, but unfortunately you can't release a PAGA claim according to the statute. Only the court can do that. But there's also an option to do a covenant not to sue, which I'll also talk about in a moment. And again, confirm that your exempt employees are properly classified. So let's talk about arbitration agreements. You all know that AB 51 made it unlawful for California employers to require employees and applicants to sign an arbitration agreement. And that was successfully stopped by a federal district court, put an injunction in place and said, nope, that violates the Federal Arbitration Act. But unfortunately, on September 16th, the Ninth Circuit, in its infinite wisdom, on the next slide, the Chamber of Commerce versus Bonta case, the Ninth Circuit said, nope, the FAA does not preempt mandatory arbitration agreements. It only preempts voluntary arbitration agreements. And this was a pretty pathetic display of judicial activism where they contorted the reasoning to the outcome that they wanted. They literally had to ignore California Supreme Court jurisprudence and US Supreme Court jurisprudence to get to that outcome. The only thing they said is, well, there's no civil or criminal penalties if you do employ arbitration agreements. So what does that mean? On the next slide, you basically have a few options. Number one, it's going to be appealed. It's going to first probably go to an en banc, which is a panel of other Ninth Circuit judges. Chances are it could get overturned at that point, but it will go to the US Supreme Court if it doesn't. And the US Supreme Court, as currently comprised, will absolutely strike down this law as violative of the Federal Arbitration Act. But what do employers do in the meantime? What about your mandatory arbitration agreements that you have all new hires sign? Well, there's a couple of options. You can stop using mandatory arbitration agreements. Depends on your risk tolerance. There are no criminal and civil penalties, and employees who are joining the company for the first time, there's a little bit more of a voluntary nature to that because they can choose not to come work for you. But if you really are a little bit risk averse and you want to kind of do the most conservative thing, offer a voluntary arbitration agreement. Say, hey, do you want to sign an arbitration agreement? Now, all an employee has to do is go online and hit Google, and your sign-up rate is going to be low. So what do you do about those that are currently in effect? Do you go back to your employees and say, hey, if you signed an arbitration agreement in the last year, we just want you to know that's invalid? No, I would not do anything. I would leave it as status quo. And personally, and I'm not the most, I tend to be a little bit more conservative. Personally, I would just keep using mandatory arbitration agreements for new hires. But I do have a lot of clients who are choosing to use voluntary. It really does come down to risk tolerance. But I am so offended by this decision as so inconsistent with the law. I think there's a little bit of that Irish rebel in me saying, no way, you're not going to make me go to voluntary. So those are your options. Do nothing, continue the status quo. Keep your mandatory arbitration agreements in place, or get a voluntary one. And for your current employees, I would not recommend rolling out new arbitration agreements. Just stand down. There's some unique PAGA issues I wanted to tell you about because, we've been talking a lot about the fact that one employee can bring these claims on behalf of another employee. And it kind of makes sense if you've got a laborer on a job site and the supervisor doesn't let them get a meal period, that laborer could represent other laborers who also worked for that supervisor and didn't get a meal period. But this law is so much broader than that. You could have a laborer working on a job site not getting a meal period, assert a claim on behalf of an office worker saying that the office worker is owed mileage for using their personal vehicle, or is owed cell phone reimbursement or internet reimbursement for working from home. Because in this case called Huff versus Securitas, the California Supreme Court said, no, any employee can sue on behalf of any other employee of the same company, even if that employee personally did not experience that particular labor code violation. Think about that. So you have somebody who's working on a job site and the only labor code violation they experienced was a meal period violation, but they can sue on behalf of Tom and Jamil and Marie for cell phone reimbursement and overtime and a commission payment. This is a very, very broad law. The other thing I wanted to bring to your mind is that you can't fix this by just getting release agreements from every employee who leaves your company, because only a court can approve a release of a PAGA claim. And that's from the case Kim versus Rhines International. But there is a provision in some separation agreements, and I include them in all of mine, where the employee agrees, I will not sue, I will not go to the labor commissioner's office, I won't sue in court, I won't sue in a class action. And I go so far as to say I will not be the plaintiff acting as a proxy for the government in a representative action. So that's me saying they're contractually agreeing they won't be the PAGA plaintiff. That doesn't mean they can't get the percentage of the penalties when the thing gets settled or it goes all the way to trial, but they won't be the face of the lawsuit. That's about as good as it gets in terms of you being able to limit disgruntled employees from taking the lead role in a PAGA action. Now, is there any good news from Tom and Marie today? Is it all bad news? Well, almost, but we had one development just in the month of September, and I've been waiting for this type of a Court of Appeal decision for years. Finally, a California appellate court said, you know what? An employer can challenge the manageability of a PAGA action. In Weston versus Staples, the court said, you know what? Deciding if hundreds of employees were properly classified as exempt, is so individualized. We required hundreds of these employees to come in and testify and talk about the duties they performed every week and assess whether or not they were performing more than 50% of their work week doing exempt duties. There's no manageable trial plan for that. We're going to dismiss that case on a motion to strike. And that was great. How does that help you guys? If you have a construction company and you are running 25 different sites and you've got employees scattered all over the place geographically with tons of different supervisors, there's a decent argument that what happened at those 25 different work sites is going to be very unique and very individualized. So we now have a potential tool in the defense litigation bag to try to start to limit these claims. So what are the other tools? Number one, reduce the penalties by immediately changing practices. And this is the ounce of prevention is worth the pound of cure. $1 that you spend today on compliance and a wage and hour audit and risk management is way more powerful than the money you spend litigating or settling these cases, because you can control and you can limit the penalties. And we've seen courts, we saw a court in Northern California say, you're not getting $100 per employee per pay period as a penalty. I'm going to give you $17. In the Carrington versus Starbucks case, Judge Bacall here in San Diego said, I'm not giving you all the penalties you're seeking. I'm going to give you $5 of meal period penalty because Starbucks had a comprehensive wage and hour meal period compliance program. And I'm not going to penalize an employer who tried to do the right thing. So compliance on the front end can absolutely help you reduce penalties on the back end. And if you have a disgruntled, toxic employee, exit them from the company in a way that they don't feel disrespected, and they want to go and talk to a lawyer. Try to wrap them up with a separation agreement or a covenant not to sue and invite them to be successful elsewhere, because what we know about the psychology of litigation, employees sue not because of what happened, but how it happened. So if you do have to exit a toxic, disgruntled, non-performing employee, do it in a way that they're not running straight to the office of an attorney who's looking for the next PAGA action to take down your company and get his or her third of the fees. Make sure that you are engaging good risk management processes. I had a client who kept getting sued over and over again, and they were, they were PO'd. They finally decided we are not doing a good job in the hiring process. So they went back and they revamped and they developed questionnaires for their top performing employees. And they had all of their candidates take that questionnaire, and they wouldn't even interview the bottom third because they were finding out that they were making mistakes in the hiring process. So having better hiring practices, doing lawful background checks in the hiring process. If you go on and you see that employees been suing a bunch of employers in the state of California, probably not who you want to hire. And then making sure you've got a very, very well established compliance program so that you make sure that you can reduce those penalties on the back end. And if all else fails, get a release agreement that says the employee promises not to sue. So Tom, tell us about the great work Cabbia is doing.
Thank you. Great job, by the way. So I like talking about our accomplishments. So what's our organization doing? We provided the first ever study authored by Len and Christine Baker. Updated study was just recently released. So we're providing data to the legislators and to everyone to really see that PAGA is just not working. It's failing everybody. We've worked with some key groups in states of Washington, Oregon, Connecticut, Maine. They were all attempting to pass PAGA-like bills. Actually, testified with the state of Washington, and they're all considering PAGA-like laws again. But believe it or not, we were able to come in with our data, with our studies, and say this law is such a failure in the state of California that you don't want it in these other states. And we were able to kill those bills. And our concern is if PAGA starts to spread into other states, it'll be that much more difficult to get it out of California. If you go on our website, there's you can do case search page, interactive maps on you know, the PAGA study, you know, to show who's affected. You can look up pretty much anything. The employer that got sued, the employees who've been suing. You can look at the attorneys that are on there. So it's pretty interesting stuff if you go on our website. We are suing the state of California, believe it or not. We started this lawsuit at the end of November of 2018. We definitely have to give a big thanks to Bruce Wick from the Housing Contractors of California, one of our largest donors in this lawsuit, had given us upwards of over $130,000 because these lawsuits are really expensive. And right now, we're challenging the separation of powers claim. And we really think it's a long shot, but it has validity because they compare it to what they call a key tam type statute. And the state really has not been able to treat it like a key tam statute. The state is actually supposed to make sure everybody gets their notice, keep an eye on, you know, mediation agreements and amounts, and be in front of the judge. None of this has happened. And again, our lawsuit, you know, in Bloomberg law, they said, hey, this is why PAGA legislation potentially hasn't passed. And we got the U.S. Chamber of Commerce who's behind us. They're writing an amicus brief with the California Business Roundtable, some other California-based trade associations. So we're pretty excited about that. And the Little Hoover Commission, we've been working with them. They're going to conduct a study on PAGA. We had a lot of meetings with them. We're going to have more. There's going to be open public hearings, and we need to rally more troops that have been affected so they can share their story. And the Little Hoover Commission, they oversee legislation in California, and we're hoping the report will say, hey, you need to do something about this onerous law. So at this point now, if anybody's got any questions, anything they would like to ask, feel free.
So Tom, we did have a question that came in, and maybe it's more directed to Marie, but we'll see which one of you can answer it best. The person asked, we talk about tools, PPE, cell phone reimbursements, etc. Would requiring boots on a job site be an issue as well?
Yeah, so I had a case involving construction industry workers who were required to wear steel-toed boots. And this is one of those situations where the federal OSHA indicates that employers don't have to pay for steel-toed boots, but the California OSHA, Cal OSHA has indicated that they do. And anytime there's a conflict between federal law and California law, you always look to the law that is most beneficial to the employee. So that would be the California law. But then you always go back to Labor Code Section 2802. Is it reasonable and necessary? If the steel-toed boot is required as a safety PPE, if you will, by the employer, and that is not just the personal preference of the employee, it's going to be very hard to argue that the employer doesn't have to reimburse that employee for those steel-toed boots. But if it's really not required for the safety on the job site, then and the employee simply preferring to wear those, like the feel of a steel-toed boot, then that would be not a requirement. So I see that there's a question that just popped in the chat. Does this apply to regular work boots too? So again, it goes back to, is this something that the employer is mandating and requiring? So BJ's Restaurants got sued where an employee said, we were required to wear these anti-slip shoes. And when the court got into the evidence, the court found that no, it wasn't really required by BJ's to wear these slip resistant shoes, but some of the workers voluntarily chose to do that. And the Labor Code Section 2802, it's not about what employees voluntarily choose to do. It's whether or not it's necessary to perform the duties of the job and if it's reasonable. So in that situation, it would come back to, is this something that the employer is mandating, or is it something that the employees choosing voluntarily to wear.
So Marie, I think in that case, understanding the questions that are being asked for us as a company, for example, we're going to tell our guys that they should be wearing boots on the job site. Let's say we're concerned about them rolling their ankle or having adequate support or stepping on a sharp object on the ground. We wouldn't want, a flip flop or a very weak tennis shoe maybe. We may not specify things like it has to be an exact height or it has to, have a steel toe to it, but we're going to say, hey, it's a job site, you need to have boots. What would you say? Because I think that's the question that's probably being presented by several companies going, hey, we all want our guys in boots on a job site. What is that required? And how do we handle it if we are concerned that that's a requirement?
Yeah, so again, we can look to the restaurant industry because they've been sued over and over again about, wearing a white shirt and a black pants. And the question becomes, is it a uniform requirement or is this suggested guidelines? And, you saw Abercrombie and Fitch got sued, Target, and they all switched to, you can wear a Dockers light pants, you can wear any black pants, any white shirt, any khaki pants that you would normally wear in your ordinary life. And the courts have said, oh, well, that's fine, because if you can wear these items in your everyday life, socializing, that's fine. But when you look at boots that would be of the nature that you described, Jamil, I don't think people are wearing those boots out to dinner. So it becomes much closer to being kind of a uniform requirement. It's for safety, because like you said, you don't want open-toed shoes. And, honestly, you want to keep your workers' comp claims down. So I would say 8 to 9 times out of 10, that goes to a court. It's going to be deemed that that is a boot that has to be paid for by the employer. And if it went to the labor commissioner's office, 10 times out of 10, that's going to be a boot that has to be paid for by the employer. So you want to try to manage that risk up front by giving employees an allowance that is reasonable. You go out and price the shoes, you tell them, here are your options, and you can do that. Or I've had employers larger, I'm thinking of, staffing companies in the construction industry where they buy in huge amounts of bulk and they give the boots out to their employees, and they understand there's going to be a certain amount that they never see again and don't get returned, et cetera, and there's turnover and attrition. So it's really going to depend on the size of your business, the operations of your business, cash flow, that type of thing. But at the end of the day, you got to ask yourself, is it worth it to have a lawsuit brought on behalf of 75 employees where they're alleging $100 for every single pay period that the employee had to wear these boots without reimbursement?
So I think that brings up
the other thing I would advise is people have to really take a look at, because I've also seen a lot of cases, because I've work with some law firms, and sometimes I'm in the middle helping. But a lot of times they have policies. You have to be so careful with your policy. They might have a policy that says you must have your own tools. You must wear this kind of boot. You must wear this kind of thing. And once you have that policy floating around out there, that's the one that's going to end up biting you, because that employee is going to take it to the attorney. And I always tell everybody, please review these things. There's somebody that's in the middle of a lawsuit, and it was over the tools. And they said, well, they make more than minimum, wage and this and that and the other thing. Doesn't matter. Now they have to defend themselves. And then I said, well, what is the cost of these tools in this toolbox that you're requiring them? It's about $39. Well, give them a $39 toolbox and move on. You have to make business decisions. You don't want to sit there and fight and try to defend these things. So I would tell everybody there, really take a quick look at whatever your policies are on PPE and tools and what you're requiring. And because that if it's shaped in that way, then you could have a problem.
So
I call it the hold the nose. Like, you got to hold your nose and just do it, because you know what, on the back end, it's so much more expensive. It's that ounce of prevention versus the pound of cure.
Right.
So this may have been answered, but I feel like it's still a little open-ended. Someone asked a follow-up question. Can we offer a voucher towards the purchase, or basically they're saying a reimbursement, or must we pay the full cost?
You have to pay what is reasonable and necessary. So if you know the boots are going to cost about $40, giving them a $20 voucher is not going to get you to compliance, and you're back to looking at penalties. So if, on the other hand, you've priced it, you've done the research, and you've looked and you see that you can buy a good pair of boots at Target and Walmart or Costco for $39.99, and you give out vouchers for $39.99, and employees are coming at you for $60 because they went to Boot Barn or something like that, that is a completely different analysis. But you have to pay the full cost that would be reasonable under the statute.
I think those are good topics because they affect almost every single person on this call and in the construction industry. You know, we look at some of these items and we're like, well, the guys might wear the boots outside of work. They might wear them when they're digging a hole in their backyard. They may choose to do these things. And it comes down to which thing hurts less.
Right.
Does it hurt less to buy the boots? Do we keep a stock of a bunch of different size boots that are worn like, you know, bowling shoes? And we tell employees, here, these are for you. And if you don't want to wear them, then you can go and buy your own pair of boots. You know, I've provided you a pair and you have what's necessary for you to be able to do. So cell phone reimbursement, someone asked the question regarding cell phone reimbursement. They said, let's see. Oh, I apologize. I'm getting all messed up on Zoom here.
It's all right. It's about they asked if there was a formula or a flat rate. And, you know, here's the thing. Again, I think sometimes people get too tricky and overthink things. I was doing a wage and hour audit for somebody, and I was going through all their stuff. And it's a huge company, and they're reimbursing the cell phones. They said they were giving them like $1.04 a month. How did you concoct this number, $1.04 a month? Where is this even coming from? And they says, well, we figured out the data and we analyzed this and we analyzed that. I said, do you realize the data is, and you said it earlier, Maria, it's got nothing to do with it. They're going to say it's going to be wear and tear. Well, how often are you using it? And then you find out that they're using this to clock in, clock out, and say what's going on with the residents that they're taking care of. So, I mean, I would kind of, you know, look at how much are they really using it. But I mean, realistically, if you gave somebody a stipend of $5 a month or $10 a month, I don't think that's unreasonable. It's better than nothing. And if you have a nice little written, simple agreement, you know, and we have those 2 cell phone agreements, and it says, if this $5 isn't enough, then you need to come back to me and you need to bring me a receipt and say, you know, it cost me more. Prove it costs more, and we'll reimburse you more. And you should be safe. I think sometimes people go overboard, you know, oh, I'm going to pay 50 or 70. You don't need to go that high. It just has to be reasonable. Would you agree with all that, Maria?
Yeah, I mean, the only guidance we actually have on the amount of a cell phone reimbursement comes from a mileage case, the Gattuso case, where the Supreme Court said there's 3 ways you can reimburse an employee for using their personal vehicle for work. You can either follow the IRS rate of mileage reimbursement, and that's going to be presumptively reasonable, you're golden. Or you can develop a stipend, or you can have the employees bring in insurance, wear and tear, depreciation, gas receipts. Who the hell wants to be in the business of gathering all of that information and coming up with reimbursement amounts? So the stipend is kind of what Tom was describing, but the court says you have to have an analysis. There had to be some good faith diligence on the part of the employer to come up with a reasonable stipend amount, which is why I recommend making sure you understand average rates of unlimited cell phone data plans, unlimited calling data plans. And then you sit down and you think, okay, employee clocks in the morning and out at night, probably sends an average of 2 texts to supervisor in the day. And that is going to be 25 minutes out of the entire week of usable time. That extrapolates to 2% of cell phone usage. Well, the cell phone bill is $100. We're going to give you $2. And like Tom said, you have to make sure that you give them an opportunity to come back and say, hell no, I'm using my phone way more than 2% of the time and way more than $2 worth. And that has to be an opportunity for that employee to come back. But if you get into litigation, they're going to want to know what your analysis was. You can't just say, oh, $5 seems good. There has to be some analysis.
So I think we have another follow-up question in regard to the boots, and I'll take a stab at answering this, and then you guys can correct me. Let's test my knowledge. So the participant asked, how frequently do you need to replace the worker's boots? So I think in this case, we would need to make some reasonable assumptions of what the lifespan of a boot is, and apply that to our expectation of what we're going to give them as a reimbursement or the stipend of, hey, you get $40 every 6 months, because we believe on average, we've looked at it, lifespan of a boot might be 6 to 9 months. So we're just going to call it 6 months for every employee. Would that be reasonable to do? And what would we do if we had an employee that every 3 months is coming in telling me, I need new boots, these are worn out?
Yeah, there's actually some guidance online about well-worn everything, what you need to know about replacing work boots. And they go through some categories about delamination and cracks and holes. And you could probably come up with a checklist: damaged toe, flexibility, falling apart at the seams, boot maintenance. And you could say, these are going to be our criteria for assessing when we're going to replace boots. Like you could, for example, have laces available, or, but yeah, I definitely think that you want to do, again, just like with the cell phone, an assessment of what is reasonable in terms of when a boot is replaced, and having some objective criteria that you can follow, because you don't want to accidentally, in the wage and hour arena, invoke a discrimination claim. Oh, Joe's white and Joe gets his boots replaced every 4 months. But, Jamil's not white and he doesn't get his boots replaced except every year. Now that's discrimination. So having objective criteria in place for assessing when boots should be replaced is a good idea. And then gather some information. Most of your supervisors, managers have a fairly good idea of how quickly these boots are going to wear out with regular use.
So let's go to our next question here. Someone asked, do you anticipate PAGA suits based on COVID-19 vaccine requirements? Perhaps based on time spent getting vaccines, or termination based on not having the vaccine? How would you defend against it?
Okay, so apologize for the dogs. Hang on a second. So I do anticipate lawsuits based on COVID-19 vaccine requirements. In the wage and hour arena, I anticipate it's going to be that if an employer mandated that employees go and get a vaccine, that any time spent going to get the vaccine should be compensated as hours worked, and any time spent recovering from the side effects of the vaccine should qualify as paid sick leave and should be compensated. And if they're out of paid sick leave, there's an argument under the Cal OSHA temporary emergency standards that they would be compensated for anything COVID related, which could include a COVID mandatory vaccine. Now, termination based on not having the vaccine, yes, you're going to see in the not, so that would be the PAGA claim. That would be the type of PSL, paid sick leave, is the basis for a PAGA claim, and uncompensated time would be basis for a PAGA claim. And if for some reason the vaccine's not free, maybe even the cost of the vaccine. In terms of the termination side of it, if an employee has a legitimate medical disability that precludes them from safely getting the vaccine, or a sincerely held religious belief that precludes them from getting the vaccine, and they're terminated after advising the employer that those are exemptions that they're asserting, yes, you're going to start seeing some wrongful termination cases based on that. Now, there are some, you need to go through a reasonable accommodation process. You need to be able to have conversations with an employee asserting either a medical exemption or a religious exemption, and try to come up with alternatives to COVID tests a week, work remotely, go through an interactive process with the employee so that you don't end up just pulling the trigger prematurely, terminating an employee.
Good. So the next question that we have in the queue is, we have some employees who work remotely, not because we require them to, but because we're accommodating their request. Does this mean we have to reimburse for their internet?
Good question. So obviously March 19, 2020, when the governor's first stay-at-home order was issued, overnight, tons of companies sent their people home. Unquestionable that that was something that the employer would have to reimburse the employee for, because the employee's having to incur internet costs in order to do their job remotely. But if you hire an employee and you hire them into a remote position, you would have to reimburse them, because that's a position that you, the employer, established as a remote position. It wasn't a choice for them to come to the office. Now it starts to get very gray and hairy when you have a situation where employees have been working remotely since March 2020, and now they decide they really don't want to come back to the office, even though it's safe. What do? If that's the employee's choice, it's kind of easy to say, well, that's their choice. That's not necessary. No Labor Code 2802 claim. But I've seen some plaintiffs' attorneys out there trying to spin this claim. Well, does the employer have a workspace for the employee at the office such that they could change their mind tomorrow morning? Or once that's decided that it's remote and the employer's benefiting from not having rent, not having the resources available for that employee to work in the office, is that an attempt by the employer to unfairly shift the cost of doing business to its remote workers? So now we're back to the hold your nose part, where if you legitimately have a concern that it may not be viewed as voluntary down the road, and that the employer is actually benefiting from the arrangement because it's not holding an office open for that employee at the corporate office, then in that situation, you may decide to reimburse the employee. I've had clients say, you know what, BS on that. I'm going to just put together an agreement and say, hey, employee is requested to work remotely. Employee knows that they can work in the office, but at employee's request, employer is going to honor this, and employee understands and agrees that they're not going to be reimbursed for any expenses of working from home, because that is the employee's request and it is not a mandate by the employer. Therefore, it's not reasonable and necessary. And you could do that. Again, it comes down to risk tolerance. Are you okay with that? You want to take that risk? If you have an employee who's leaving the company, unfortunately, Labor Code Section 2804 says that you can't release an expense reimbursement claim. So it comes back to, what do you want to do? Do you want to pay that upfront, or do you want to pay it in a lawsuit later?
And there's some companies that treat it just like the cell phone stipend. You know, they say, hey, sign an agreement. We'll give you $30 a month. We'll help you with your internet. You know, and you can figure out reasonable time and what data they're going to be using and such and such. And, you know, I always say
exactly the same. Yep.
You know, it's you don't want to hire somebody to defend you over, you know, $30 a month, you know, times 4 or 5 people, or how many people are working remotely. It's just not worth it. I mean, you know, these cases, I mean, you see, I mean, you're going to be into, you know, $500,000 before you even know it, and you're not even settled yet.
Right. You
know, we say, hey, it's $1 million for this case, and the other attorney got, $333,000 or $400,000. Well, how much is Marie going to get defending you? You know, that's not going to be cheap either. I mean, yeah. So you have to look
I call that the burn rate. I mean, the burn rate on one of these PAGA wage and hour class actions, when the case is going hard and there's discovery and time records and wage records, and you're having your employees sit for deposition, and your head of HR and your head of labor relations is sitting for deposition, you're talking anywhere between $30,000 to $50,000 a month in attorney's fees just defending the case before you pay a penny to settle the case.
Yeah, and not to mention your own employees. You guys are, everybody's doing stuff that's non-productive work.
Right, you're distracting them from the business that you actually, exist to do.
Right.
I think it's fair to say that none of us will be completely protected from experiencing a PAGA claim, regardless of how many loose ends we tie up. But the more loose ends that we do tie up, the harder it makes for the attorneys that want to sue us to find something. You know, they're looking for that quick and easy piece, that wage stub violation, the keywords that a disgruntled employee may say that trigger them to say, oh, there's a claim here. And the more policies and reimbursements and pieces we kind of deal with ahead of time, the faster it's going to be for another attorney to look at that and realize, hey, there's not going to be an easy win here, and they'll focus their time and energy hopefully on other employers that maybe aren't as sophisticated, let's say. So I'm getting some really good feedback on our panelists. So I want to thank you, Tom and Marie, for taking the time out of you guys' schedules to come and help educate our association and our members on PAGA, how we can defend ourselves against it. You know, there's all these little nuances. If you are listening to this presentation today and you are not already a member of CABIA, Tom's organization, I'd highly encourage you to check out their website, cabia.org, to look at the resources that they have there. Consider supporting them. Tom and I were talking yesterday. There is some hope on the horizon. We're constantly looking at, you know, ways that we can overturn PAGA and deal with some of these issues to make it more appropriate for the employer and the employees. Right now, there's some legislation that's being proposed that would help to reduce some of the issues with PAGA, but it's something that still needs to be analyzed. I think, Tom, as we were talking yesterday, would you agree with that? We need to kind of look through that and look at where it's at in the legislative process. And we're looking to see, you know, the authors of that legislation, who can get behind it, if they can actually get this on the ballot next year or not. So there may be some new information coming in the next couple months. If the proposed legislation is able to be put onto the ballot, you know, then we'll be reaching out to talk about how we can support it as an industry. And Marie, I thank you for being on the call today as well. You're a well of knowledge that I wish I could have you on staff all the time.
I hope you never need me.
Well,
no, I'm happy. Thank you, Jamil, for putting this together. And thank you, Tom, for continuing to fight the good fight.
Thank you. And we look forward to it. If you guys don't have a good labor and employment law attorney to reach out to, I would highly recommend Procopio or any of your existing relationships that you trust to get them in on a regular basis. I know for myself, as in our organization, we often call and ask questions and we email, but I almost need, you know, Marie to come in and sit down with us and say, hey, just watch what we're doing and just listen for a day, because there's all these little hidden pieces of questions that we come up with going, well, now we tell you one more thing, right, Marie? And it changes the slant of what the advice is. So it's important to have good counsel. And while all this is an expense up front, I can tell you from my personal experience, it's better to have the expense up front than to be dealing with the unknowns on the back end. So thank you all for joining the presentation today. I'd encourage you to speak to your friends and other business owners, charities, your churches about the risks of PAGA and what they can do to protect themselves so we don't find ourselves on the opposite end of this conversation. Thank you and have a great afternoon.
Thank you.